Be ready. Start. A dispute arose as to whether the two surviving sons of the testator would take the properties to the exclusion of the widow of the eldest son in respect of the share that he possessed after the testator's death. Stop. The trial court held in that case that the entire property was to go to the two surviving sons. Stop. In appeal, the High Court reversed that decision. Stop. Their lordships of the Judicial Committee agreed with the view of the High Court. Stanza. I think the proper course is in the first instance to examine the language of the statute and to ask what is its natural meaning, uninfluenced by any considerations derived from the previous state of the law, and not to start with enquiring how the law previously stood and then assuming that it was probably intended to leave it unaltered to see if the words of the enactment will bear an interpretation in conformity with this view. Stop. If a statute intended to embody in a code a particular branch of the law is to be treated in this fashion, it appears to me that its utility will be almost entirely destroyed and the very object with which it was enacted will be frustrated. Stop. The purpose of such a statute surely was that on any point specifically dealt with by it, the law should be ascertained by interpreting the language used instead of, as before, roaming over a vast number of authorities in order to discover what the law was extracting it by a minute critical examination of the prior decisions. Stanza. Section 111 of the Succession Act 1865 came for interpretation in that case with a view to finding out if under that provision the legacy bequeathed by the father was subject to the happening of the uncertain event mentioned in the will after the death of the testator. Stop. On a reading of the section itself, it was found that the legislature had made it clear that unless the uncertain event mentioned in the will, namely the death of any son leaving no male issue, happened before the testator's death, the legacy dependent upon that will not fructify. Stop. The bequeathed fund will be payable or distributable as the conditions may be at the time of the testator's death. Stop. It does not appear from this decision that words of general import used in the preamble will control or expand the meaning of the enacting provisions. Stop. On the other hand, what was insisted upon in that case was that the language of the statute is to be examined in the first instance. Full stop. Over.